So, what are different ways that you can pass property to your spouse and save on estate tax? Hi, my name is Claire Langton-Yanowitz, and I'm an attorney at the Yanowitz Law Firm, where we help clients save on estate taxes with wills, trusts. And today I'm here to talk to you about different ways that you can pass property to your spouse that will save estate taxes. So, first of all, Minnesota has an estate tax exemption of $3 million. And that's in 2023. And couples don't automatically get two exemptions. So just because you're married doesn't mean you get to pass $6 million to your kids without paying estate tax. In fact, if you don't have a plan in place, if you just hold everything jointly or list your spouse as a beneficiary on all your assets, you're only going to get one Minnesota exemption. So our goal in estate planning is oftentimes to get our clients, if they have more than $3 million, more than one Minnesota estate tax exemption. And today I'm going to talk to you about two different tools that we have in our toolkit to do that. The first is called a disclaimer trust, and the second is called a fractional formula trust. And this is a little bit of a technical presentation, so my apologies up front. But let me describe to you how a disclaimer trust works. So a disclaimer trust, when the first spouse passes away, the surviving spouse gets to decide if they are going to set up this trust, okay? And for their benefit. And this trust can be created under a will or under a revocable trust. And they have 9 months from the first spouse's date of death to decide if they're going to set up this trust. So there's a time limit, and they must do it before they start collecting assets and putting it in their own individual name. So if Bob and Sally are married and Bob dies, Sally has 9 months from Bob's death to decide if she's going to set up this trust. And she can't start collecting Bob's assets and putting it her name first. They have to go from Bob directly to this new trust. Now, Sally can be trustee of this new trust, and we can set it up so that broad and flexibly Sally can withdraw the assets if she needs them for her benefit. But if the assets are not touched and stay in the trust, then all the assets in that trust that she inherited from Bob at Sally's death are not going to be subject to Minnesota estate tax. And so that is very key. We like disclaimer plans, the one where you have the option to setting up this trust. We like those for clients who have close to $3 million because we call them wait and see plans. We don't know if they're going to need to set up this credit bypass trust or not. We're going to wait and see what are the rules at that time. What is the Minnesota exemption at the time of death? What is the health of the surviving spouse? And, what does this client's asset situation look like? Have their assets increased in value? The stock market has done really well. Maybe they've had a medical assistance spend down. And so we are not concerned about Minnesota estate tax anymore. They have well under $2 million. And so those are all factors that we take into play. Now, there are some downsides to having a disclaimer trust plan. First downside is that it's inflexible, okay? If this trust is set up and for Sally, and it can be set up for Sally and Bob's descendants, their 3 children. It's set up for Sally and their 3 children. And let's say one of those children is met with a car accident and all of a sudden becomes disabled. And at Sally's death, the money would normally flow from this family trust to this child outright, directly to this child. And that no longer needs to happen. Or maybe let's say this child dies and we want to pass assets to the child's spouse. A disclaimer trust plan is a bit inflexible because it doesn't allow Sally to kind of alter how the beneficiaries of the trust inherit through what's called the power of appointment. So she's not able, without court intervention, to kind of alter how the beneficiaries pass on this trust. So that's one downside of these disclaimer trust plan. The second major downside is that you have to meet the requirements to set up the trust. If you wait too long, you wait 10 months after your spouse dies before setting it up, Or you start collecting all the assets and you forget to meet with an attorney, you forget that you have a disclaimer trust plan, you start putting them all in your name. Once you put them in your name, you can't undo it. It's like the glass that breaks. You can't put it back together. Okay? So now I'm going to switch gears and I'm going to talk to you about fractional formula plans, how those are different than disclaimer plans. So with fractional formula plans, we are going to set up this trust at the first spouse's death. There's no decision to be made. So you can't mess it up. If you do it 10 months after death, if the surviving spouse starts collecting assets to their name erroneously, we can still stuff them back in the trust. So they're harder to mess up. I would say the downside with fractional formula plans is that if for some reason there isn't a good reason to set up the trust, it basically interjects a degree of complexity that's not needed. So when would the trust not be needed? Let's say the exemption's gone up, the family's assets have gone down. Maybe they move to a new state where there isn't an estate tax, or the estate tax exemption is much higher than Minnesota, and so this trust is no longer needed. If those things happen, we create an ability in our trusts, we call it like the escape exit door, where we can appoint oftentimes an independent trustee to terminate the trust, to say that the benefits of having the trust in place are outweighed by the detriments, and so therefore that trustee is going to terminate the trust. So we do create the ability to get rid of the trust if it doesn't make sense in the future. But if someone is truly below the Minnesota exemption, it's not needed, it's a little bit of a hassle to have a fractional formula plan. Now, another complexity of, having fractional formula is you are setting up this trust. There's no decision to be made. And so that means that the surviving spouse is going to have a little bit more complexity with their financial affairs. They're going to have to file a tax return for this family trust every year it's in existence, so there's an extra tax return. They're going to have to segregate their own assets from the family trust, so they have different pots of money. And then finally, trusts reach higher income tax brackets faster than people. They have compressed income tax brackets. And so if the surviving spouse is not in the top tax bracket, oftentimes we recommend that if he or she is not having any sort of liability issues, like they're getting divorced or sued, it can oftentimes make sense to pool the income out of this family trust every year and distribute it to the spouse, because then they can pay lower income taxes on the income earned by the trust. Well, thank you so much for your attention today. This is a really complicated topic, so thanks for staying till the end. If you're interested in learning more about estate planning, watch more our YouTube channel, and also hit the subscribe button so that you are notified when we upload new videos to our channel. Thanks so much.